I wasn't able to get you the information I wanted because the Kansas court website has been down all day, but I think this guy's middle name is Dahmer, but it might be Donner, but Jeffrey Dahmer? Donner? Browning? I don't know. Thought it was interesting. But his reason for wanting bond is interesting too. Let me know what you think. Is that a valid reason to let someone out on bond, or is that just, part of your punishment?
This is State of Kansas versus Jeffrey Dahmer Browning. Butler County case number 2023 CR 456. James Watts appearing as defense counsel. Defendant Browning appearing from the Butler County Jail's Zoom location. Darren DeVinny, county attorney, appears on behalf of the state. This matter appears to be before the court on a motion to modify bond filed by the defense. Mr. Watts, you may proceed further.
Thank you, Your Honor. Judge, I'm not going to expand any beyond the motion. I would ask, as I noted here, the bond at this point, as I understand it, is set at $7,500. That's what my client tells me. That doesn't sound like an unreasonable bond in and of itself, but it's one he's obviously unable to make because he still sits inside the jail. He would, it looks like at this point, we believe, be a C on the grid, although obviously we cannot know that with certainty prior to a PSI.
When he says C on the grid, he's talking about the sentencing guidelines that many states are developing. That's like a numeric system where you add up the numbers for your past crimes to determine what your sentence should be. If anybody's interested, I could probably compile it and go over a couple of them, but this is what Kansas looks like.
His most important problem, however, appears to be that he has been evicted by the property he was living at, and he has a limited amount of time, and I'm guessing at this point about a week to a week and a half, to remove his property from that residence. If he's not able to do that, it's likely he's going to lose that. And as he put it when I met him at the jail, everything he owns is in that residence. If he's not able to remove it by the time his deadline runs out to move out of that property, he's probably going to lose all that items and he'll end up with nothing when this is all over. He has no objection to electronic monitoring. If the court believes that's appropriate, he would be able to stay in Wichita with his mother. But we would ask the court to consider modifying his bond either to an OR bond in the amount that the court believes is appropriate, or a bond in the something he has the ability to make. I would guess somewhere in the $2,000 range rather than $7,500.
Your client doesn't have the mother, a sibling, a friend, or an acquaintance that could help him with moving his stuff out of a place?
It sounds like no, Your Honor.
What's the state's position regarding this request, Mr. DeVinny?
Well, Your Honor, he had a fiance, and that's the victim in the case that could have helped him. But I think the bond is extremely reasonable given the level of the charges, given the defendant's criminal history. And when I look at the bond factors that we would normally cause to determine what a bond recommendation or bond determination should be, looking at just the level of the charges, the nature of the charges, those types of factors, I think $7,500 cash or surety is extremely reasonable considering this defendant has had 2 failures to appear in 2022. He's had an arrest for failure to appear as recently as December 1st of 2022. So the state has a concern certainly about his ability to show up for court, that he will return to court. But again, the dollar amount isn't extremely significant. At $7,500, contacting a bondsman to see what, if any, this treasured property that we're trying to so desperately to hold on to could certainly potentially be the basis for a bondsman to take into consideration as collateral for a bond if he wants to negotiate that. But state's position is it's a reasonable bond at the level it's at, and should continue. If in the alternative, if the court is interested in Mr. Watts's proposal of converting this to an OR bond and putting him on electronic monitoring, I think that would be at a minimum required. And certainly we want to make sure that there is a zone of protection around the victim at her residence as well. It sounds like the defendant's intention would be to move to Wichita to stay with someone there but at the same time, Judge, he's got a place to live in Wichita. I'm not sure if this same person couldn't help him dispose of his property, but property disposal and personal property moving, having it taken care of, this is not, honestly, it's not a bond factor. And his whether or not he's going to return to court is not dependent upon what happens to his personal property.
Well, so noted, Mr. Devaney. Court will take this motion under advisement for the moment. Mr. Watts, I do note that in looking at the notes from first appearance, that this case has been set out to November the 20th on a PHC docket. That's the next setting. That's a little bit troublesome for the court. I hate that it's so set so far out with a guy in custody. Have you talked to your client about whether he really wants a preliminary hearing or not?
Actually, Judge, when I went out and talked to the jail, he wrote me, and he wrote specifically about the bond. We haven't really discussed a whole lot preliminary hearing, although, so we have discussed it as to what we were likely to do. My inclination is that he's likely going to ask this case to be set for a preliminary hearing, but we have not finally made that decision.
Well, I'm going to go ahead and set it. I don't want the possibility that this case is set out to December or perhaps even January by the time we get to November 20th, given the current circumstances of this case. I'd rather get the case set while we have everybody here.
One moment, Your Honor. I noticed, Mr. Browning, did you have something to say to the court on that subject?
I do. My whole thing is I'm trying to get out there to be able to test with TFI so that way I can show some sort of effort so I don't lose my son next month, because I have a permanency hearing over my son this coming month. I'm trying to actually get out to be able to go to Mears treatment, inpatient treatment, where I can go there and also enter their reintegration program once I am completed with their 28-day program. I'm not going to be running nowhere. My son is my main priority, and if I run while on a monitor or run out period and don't show up for court, that's me also running out on my son and just abandoning him, and I can't do that to him. His mother is out there not doing what she needs to be doing to save our son. I need to be able to get out and be able to go out there to do what needs to be done so I don't lose my son.
Well, thank you for that information, Mr. Browning. Scheduling business first. Council, I will propose 3:00 p.m. on Thursday, November 9 for a preliminary hearing in the case. This would be an evidentiary setting. November 9, 3:00. Mr. Watts, your availability at that time?
Judge, it looks like I have a case starting in front of Judge Crum at 2:30 on the 9th.
What about earlier in the afternoon, Mr. Watts?
I have 1:30 in front of Judge Hartlett. Looks like that's a sentencing docket, and I'm gonna have to get out of that one quickly.
Okay. I'm going to address my assistant. It looks like that maybe I could set this in the morning at 10:30
I can
on
do that.
November 9.
Um,
November 9, 10:30. Council,
Judge,
check your calendars for that.
Judge, on November 9 at 10:30, I'm in front of Judge Crum on a pretrial date with 1, 2, 3, 4, 5.
You're a
Looks like
busy guy, Mr. Watts.
It's a busy day on the 9th. Yes, sir. 7 cases.
Covering duty that day here at the courthouse. I could propose Tuesday, November 14. Your availability then, Mr. Watts?
Well, that will work, Judge, assuming I'm not in trial for any of those that are set for pretrial on the 9th. And
Yeah.
again, at
And
that
what's
point,
the
I don't
likelihood?
know.
You don't know? Okay.
I really don't know whether they're going to go.
Just trying to allow a little bit more than an hour. I might propose Monday, November 13 at 10:45 a.m.
Yes, sir.
Would that work?
Yes, sir.
Okay, Mr. Devaney, your office can make that work?
That's fine, Your Honor.
All right, I'm going to set an evidentiary preliminary hearing in this case for Mr. Browning for Monday, November 13 at 10:45. Should be sufficient time for presentation of evidence. 10:45, Monday, November 13, evidentiary preliminary hearing setting. I will note for the record that that is a date 7 days sooner than his preliminary hearing control was originally set in the case. So the court has tried to expedite that setting. That setting is done as a prelude to the court's ruling. I agree with Mr. DeVinny. I think this bond is reasonably set where it is. One factor that the court must consider is what the very purposes of bond is to ensure appearance, but there's also a statutory provision which allows the court to consider public safety. This is a violent crime, Mr. Browning. Now, at this point, you've got a presumption of innocence, but the charge before the court is that you feloniously choked your domestic partner. It does appear that there may be issues regarding the safety of one or more individuals in our society should you be released. I'm not inclined to modify this bond. I think it is reasonably set. I regret you don't have the immediate financial resources to make an appropriate arrangement with the bondsman, but I'm going to leave bond where set at $7,500 cash or a professional surety required with the same restrictions as before. No contact with the victim, obviously, is the only thing that's listed on the docket sheet. No alcohol or drugs, obviously, if you do make bond, Mr. Browning. And I hope you can communicate with somebody in the outside world regarding this personal property issue, but I agree with Mr. DeVinny. The fact that you may lose property as a result of the accused behavior and because of your current detained status is not really a factor for this court to consider. That's just an implication of what's happened in the case. So the request to modify bond at this time is denied. Preliminary hearing set November 13, 10:45 a.m. Mr. DeVinny, is there anything else from your perspective that we still need to address?
No, Your Honor.
Mr. Watts, anything further at this time?
No, Your Honor. Thank you.
Very well. Then the Browning matter will currently be in recess at this time.
Your Honor?
Yes,
Will that be a Zoom hearing or in person?
the evidentiary prelim is contemplated to be by Zoom.
Yes, sir.
Okay, thank you. The matter is in recess. You may end the meeting for all, Mandy.